Good morning and welcome to the Successful Bid Protest webinar. Today's program is brought to you by the Pacific Northwest Defense Coalition and K&L Gates. The Pacific Northwest Defense Coalition is an association of Northwest defense and security industry businesses. PNDC focuses on strengthening our member business growth, our regional economy, our national security through training, one-on-one counseling, business-to-business networking, and advocacy. Today's program will focus on bid protests. Federal government procurement contracts may be protested by bidders or other interested parties. This webinar will review this process as well as tips on how to make your protest effective and successful. Today's presenter is Paul Bowen, partner with K&L Gates. Mr. Bowen is a partner in the firm's Government Contracting and Procurement Policy practice and represents companies in all aspects of government contracting, with a focus on contract compliance, investigation, mandatory disclosures, disputes, claims, bid protests, protection of intellectual properties, suspension and disbarment, and ethics. K&L Gates, LLP, comprises more than 2,000 lawyers who practice a fully integrated office located in 5 continents, including Pacific Northwest offices in Seattle and Portland. If you have questions during today's webinar, please type your questions in the webinar dashboard to the right under the Question tab. You may ask a question at any time during the presentation. Most questions will be addressed at the end of the program. Please see the Handout tab for a copy of today's presentation and a list of upcoming PNDC events. Thank you for joining us today. Paul, you may begin the presentation.
Great, thank you. I appreciate the introduction, and I appreciate everybody joining us today to talk about bid protests, taking a little bit of time out of your day. I don't have much to add to that introduction. It was pretty comprehensive, so thank you for that. And we can probably just jump right into the topic, which, as you can see on the first slide here, is protests a primer for success. Now, this topic is, if you've ever dealt with it, you know that it's a broad topic, and we could probably spend a day or two just talking about the topic and the nuances of the topic. For those of you that have never dealt with bid protests before, this is just a very high-level overview of some of the primary issues that you will deal with if you're ever involved in a bid protest, or that you could be involved with a bid protest. So hopefully this will help you issue spot and know when and where you might need to seek assistance and how best to approach something. On the first slide here, you can see that I have an outline here of the topics that we're going to cover over the next 40 minutes or so, including some relevant definitions, types of protests. There are 2 general categories that we can break it into. Proper subjects for protests. You know, what is something that GAO or a court might recognize as a proper topic or subject for a protest. The different forums in which you can bring a protest. There are several. The timing requirements, which are very important for filing a protest. Automatic stays of performance of the contract or the award of a contract if a protest is filed. And then I've just provided some general tips in no particular order that I think will be helpful in better understanding protests and also guide you if you ever run into one. So with that, we will jump into it. With respect to definitions, there are several places that you need to go. If you ever want to look into it yourself, I've put the 3 primary areas up here. One of them is the Federal Acquisition Regulation, or the FAR, subpart 33.1. That is not only contains the regulations and definitions for agencies, but also implements 4 CFR Part 21, which are the implementing regulations for protests at the GAO. And I'll dive into those a little bit deeper, but these are the sources for most of the definitions that you will need and that will be relevant. The GAO website also includes a lot of helpful information, quite honestly, and there's one link there in the slide, but also they have what they call a descriptive guide in addition to posting actual decisions from the GAO on their website. I would say even if you have experience with protests, it's always good to just use that information available on the GAO website as sort of a guide or a refresher once you get involved in it, in a protest, either as a protester or as an intervener. As I had mentioned, there are several different agencies in which you can bring a protest, and there are pros and cons, or not agencies, forums in which you can bring a protest, and there are pros and cons to each. We'll cover that a little bit, but the 3 general forums are the agency. Yes, you can file a protest at the agency. There's some real disadvantages to doing that, as you can imagine. There are some advantages, but the most common forum is at the GAO, and then you can also file a protest at the Court of Federal Claims. That is a little more formal than the GAO, and it is actual federal court litigation. So as you can imagine, it's usually a little more involved. So what is a protest? A protest is a written objection by an interested party to either a solicitation, the cancellation of solicitation, an award or a proposed award of a contract, or the termination or cancellation of the solicitation. It's important, out of that definition, it's important to point out the definition of interested party. I mean, a protest is somewhat self-explanatory, but only an interested party can bring a protest, and an interested party is defined as an actual or prospective offeror whose direct economic interest will be affected by the award or failure award. And you see there in a parenthetical, I supplied both the FAR reference and the CFR reference for that definition. And that definition generally is adopted by the Court of Federal Claims as well. So the interested party definition is an important one to consider if you are filing a protest, or even if you're deciding whether or not you want to intervene. The forum or the venue will consider lots of different factors when determining whether or not you're an interested party, including the nature of the issues that have been raised in the protest, the relief sought, the party's status. And if you are not an interested party, it is a bar to bringing the protest. Let's dive into that a little bit deeper. Some examples are maybe a large business that's protesting a small business set-aside contract award. I know that sometimes that actually pops up quite frequently, where somebody wants to protest whether or not they have the opportunity for participating in a certain award. Now, when I say protesting in this context, I'm talking about protesting a proper small business set-aside award. Now, there's a possibility you can protest, obviously, if they've improperly set something aside. But if it's a proper set-aside, you're a large business, you're simply not an interested party because it has been set aside for small businesses. Another example of when you're not an interested party is if you wouldn't have been in line for the contract award. So say, for example, it's competitive procurement, maybe a lowest price technically acceptable procurement. Let's say that you were third in line on lowest price, you were technically acceptable, but even if you knock out the awardee, if there was somebody who was also technically acceptable and even a lower price than you, then arguably you're not an interested party because even if you're successful in the protest, the award would end up going to somebody else, or the competition would favor that person who's in line ahead of you. You're also not an interested party if you can't perform the contract. If you're suspended or debarred, clearly you're not an interested party because you just don't have the opportunity to perform. Other examples might be where maybe you can't perform because you're not an approved source. I've seen those before. So say, for example, you have to make a certification that you have the ability to perform. You either have the technical data package that's required or some other function that's required by the solicitation. If you can't make that certification, then you're likely not an interested party. I will point out, however, there's an opportunity to protest, and we'll talk about it a little bit later. There's an opportunity to protest if there are restrictions in the solicitation that are overly restrictive, if the agency has made it too difficult for competition and it's unreasonable and doesn't meet they can't justify that it meets their minimum needs for the procurement, then there may still be an opportunity to protest. In the Court of Federal Claims, a protest is essentially the same thing, except, as I mentioned, it's an actual lawsuit by an interested party objecting to either the solicitation, a proposed contract, or award of contract, or if the agency has violated any laws in connection with the procurement. You see the statutory reference down below at 28 U.S.C. 1491. That's reference to the Tucker Act, which essentially is the statute in which the U.S. waives its sovereign immunity, allowing you to file a lawsuit against the U.S. In federal court. There are a couple other notes there. You can see the different violations of law or regulations. There's sort of some examples in those bullets there. Types of protests. I had mentioned that there are two just general buckets that they can be broken into. One is a pre-award protest, and that's generally a challenge to the terms of a solicitation. If you receive a solicitation, you have to file that, and we'll get into the timeline, the deadlines for filing, but it's essentially a challenge to the terms of the solicitation, whether it's too restrictive, whether it is ambiguous. And then there are also post-award protests, challenges to the award or proposed award of a contract because of some impropriety taken by the agency in complying with the solicitation terms or complying with regulation. Essentially, they didn't conduct the procurement as they were required to do by the solicitation or regulations. Pre-award protests, some proper subjects for a pre-award protest, and this is important because when evaluating whether or not to bring a protest, you obviously, one of the primary and first questions I'll get is, is this something worth protesting? With respect to pre-award protests, here are some general examples. An improper sole source award or proposed award, I see those occasionally. Essentially, under FAR Part 6, the government is required to compete procurements. Now, there are some exceptions to that other than full and open competition, but the agency has to strictly comply with that. It has to fit with into one of the exceptions of full and open competition. If you feel that if you get a notice from the agency or see a posting of a notice for a sole source and you believe that the agency isn't competing this as it's required to, that procurement would need to be brought, or that protest would need to be brought as a pre-award protest before the deadline for proposals. Patent ambiguity in an RFP. If you receive a solicitation or an RFP and in that there are terms that really just don't make sense, or you think that it's going to make it difficult for you to compete because of that ambiguity, don't glaze over it. Don't ignore it. Too often I have seen people fail to protest an ambiguity in terms, and later, after they get the decision and find out that the ambiguous terms somehow adversely affected them in the procurement, they'll come and ask whether they can file a protest. And more often than not, the answer is that your protest is untimely because this is a pre-award protest rather than a post-award protest. And as I said, we'll get into the timeliness. It's very important to follow those rules. But patent ambiguities, as opposed to latent ambiguities, need to be protested pre-award. RFP evaluation criteria improperly favors an offeror. If you see in the solicitation that the solicitation has been geared to a particular company, and improperly so, whether it's done by being overly restrictive or whether it is actually specifying terms and technical data or other requirements that only one person or one company can fulfill, and it's unnecessary for the agency to do that, then that's something that you need to bring up as a pre-award protest, or is available as a pre-award protest. If the other category is that the RFP just otherwise just violates the laws or the regulations that the agency has to comply with in conducting procurements. I put this parenthetical here. It actually applies to really both the last two bullets here, but I'd mentioned it earlier. In order for an agency to restrict competition properly, if the solicitation terms are tailored to restrict competition or has the effect of restricting competition, it is the agency, if the protest is filed, it is the agency's responsibility to be able to show that the restriction of competition is necessary to meet the agency's minimum needs of the procurement. So that falls on the agency, and that's their burden in such a protest. If they can show that, if there are reasonable restrictions through the terms in order to meet the agency's minimum needs, then it's unlikely the GAO would sustain your protest. What about proper subjects for post-award protests? We have several here, and there's some overlap, and quite honestly, there's a long list of different protests that you can bring. But here are some general ones: an improper or unreasonable evaluation. If the agency sets forth the evaluation criteria in the solicitation, and it says that it's going to conduct it in such a way, it has to make sure that it applies those evaluation criteria evenly and fairly across for all competitors. So if and in fact, the documented source selection has to reflect that the decisions made are actually reasonable. If you can show or you feel somehow that even though they complied with the evaluation criteria, if they were unreasonable in their determination with respect to scoring your proposal, that's something that you can protest. Failure to follow evaluation criteria. If the agency sets out how it's going to do the evaluation, if it does not consider certain evaluation, or if it uses the following bullet, if it uses unstated evaluation criteria, that is an available basis to protest an award of a contract. Failure to perform price cost analysis. And this is a big one. This actually has been one of the more prevalent protest bases that I've seen, especially in 2015. It seems like this was, and I have a list of some of the more recent protests based on what GAO has put out, but failure to perform a price or cost analysis when required by the solicitation or the regulations, that one has become a significant one. And essentially what that is, if you're not familiar with it, the government has to make sure that it is buying something at a fair and reasonable price. If it's a fixed price contract, the agency generally doesn't have to dive too deep into the price evaluation. It just has to make sure that it's fair and reasonable. If, on the other hand, in the solicitation, the agency states that it's going to do a price realism analysis, which is different from price reasonableness, where it's actually going to go into the pricing to make sure that it is realistic, that the offeror actually understands the terms of the solicitation. If the agency commits to doing that, it has to do it, and if it fails to do it, you can you can have a sustained protest, or the agency will take corrective action. Now, with respect to a cost-based contract, the agency generally has to do a cost realism analysis for most procurements, and again, it has to go in and evaluate whether or not the costs being proposed to be reimbursed are realistic. So that's very high level. That could be another day or 2 or 3 days, quite honestly, on just pricing of government contracts. But that's a general rule of thumb that can help you understand that bullet point. Improperly documented source selection decision. If the government is required, the agency is required to document the procurement process and its source selection. If it fails to do so, then that can be a ground to protest the procurement. Now, the difficult part about that, however, is that you generally don't know that right off the bat. That usually comes up in a supplemental protest, and we'll talk about that a little bit later. But you file an initial protest, and then usually after filing your protest, 30 days later, the agency has to disclose or provide an agency report, which will include, its arguments in connection with the validity of the procurement, but also it includes documentation. From that, you can get a good idea whether or not they properly documented their decision, and then you have 10 days to file your comments in a supplemental protest. So, it's rare that you can identify an improperly documented file as an initial protest, but certainly as a supplemental protest later once you get the report, those can pop up. Improper discussions. If the agency is going to have discussions with the offerors, it's required to do so in a fair way. It cannot have discussions and allow one offeror to revise its proposal and not allow the others to do it. It has to be done equally. Awardee has an organizational conflict of interest. OCIs are something that pop up frequently in protests, and it essentially, without diving too deep into the weeds, it essentially is if the offeror has something that prevents it from being objective in either the performance or evaluation of the contract. If it has inside information that gives it a competitive advantage, all those can end up being organizational conflicts of interest, and if you have one, you're likely to get a protest from another offeror. Improper subjects for protests. We've covered it. I've covered a few of these in just talking about the proper subjects, but there are a couple that I can point out. Budgetary actions. You're not going to be able to protest whether or not somebody is actually, or whether an agency is actually appropriating funds to a certain procurement. That's usually not going to fly. Contract administration matters generally. An example of that might be if an agency exercises its right to terminate a contract for convenience, and it's done properly, you're not going to be able to protest that. That's a contract administration matter, and GAO is not going to listen to that one. Or even the issuance of a modification, unless the mod does something. For example, if the mod ends up acting as a sole source procurement, where they should have competed it, but the modification has a scope of work so different that from the original contract that maybe it violates the competitive procurement requirements. Subcontract awards, generally not proper for protest. The other one is grants and cooperative agreements, subcontracts, or subawards under those. The protest jurisdiction generally is limited to procurement contracts at GAO and the agency. If you have a grant or cooperative agreement, the appropriate venue for that, if any, is going to be at the Court of Federal Claims rather than at GAO. Let's talk about some of the pros and cons of each of the forums. The first one, let's talk about the agency. As I said, you can file a protest at the agency. It's usually the cheapest. It's the least formal, and it can be quick. FAR says best efforts to get it done within 35 days. The disadvantage is, as you might suspect, it's a road game for the protester. You're essentially going back to the agency and saying, hey, look, agency, you guys violated the solicitation. You didn't follow the solicitation, or you violated the applicable regulations. Unless it is particularly egregious or a very clear error, you're unlikely to get relief at the agency level. Now, maybe there's some other reasons you might want to file at the agency. Especially, as I said, pointing something out that you think maybe the agency just didn't catch, and you can avoid going to GAO or the Court of Federal Claims. You're unlikely to get an agency report or other documents as you would at the GAO or at the Court of Federal Claims. The other thing that you need to be aware of, and this will be on a later slide, but if you file at the agency, you have to be very aware of the fact that just filing at the agency doesn't get you any protection of a stay of performance of the contract at the GAO. And I'll explain that a little bit more, but if you file at the agency, just be aware that although the agency may be staying performance of a contract that it's awarded, or it's holding off, it's a pre-award if it's holding off on awarding a contract, if it goes outside of the agency to GAO or later, to Court of Federal Claims, the agency's decision to stay doesn't carry over to GAO. So you're going to have to make sure that if it moves forward, you also get the stay at the GAO. And I've already talked about it. You may not get effective relief from the agency. I will point out that in some instances you may be able to go above the contracting officer to get an independent review of the decision. That's not in every case, but it's something to consider. However, it's still a road game for you as the protester filing at the agency. Even if it goes above the contracting officer's head, it's still likely to be difficult to get relief. GAO. This is the most common forum venue for protests. It's less expensive than the Court of Federal Claims, but it's more expensive than filing at the agency. And this is generally. I'm sure there are some outliers, but it's considered by most to be the best venue to get an impartial decision, most likely to question the agency's decision. It's debatable. Some people might say you have a better shot at the Court of Federal Claims, but GAO honestly is a pretty fair forum for these protests. Time of decision is predictable. Generally, the protest has to be decided by GAO within 100 days. There is an express option. It moves quickly. As I mentioned, you file the protest, and within 30 days you have the agency report generally. And then within 10 days you generally have to get your comments and any supplemental protest in. So you're looking 40 days after award. The agency can take the next 60 days or so, if my math is correct, to make a decision. It doesn't have to wait the 100 days, but it generally has to be done within 100 days. The GAO can act quickly if it sees clear error, and this has happened in actually a couple protests that I've been involved in, where it does what it calls an outcome prediction. And in fact, this is similar to federal court, where I've been in federal court and the judge pulls you aside and might sort of say to the parties that they have an idea which direction this will go if they have to go to final decision, and the parties might want to reconsider their position. including if you're the agency taking corrective action. I've seen it happen. Usually the agency, if it's going to take corrective action, doesn't need an outcome prediction from GAO to take corrective action, but GAO can act quickly if it sees the need to do so. Discovery, it's not real discovery as you would see in federal court. It's the agency report that I've already discussed. The agency has to turn over all of its documentation relevant to, or almost all of its documentation relevant to the procurement, how it's documented it, providing its justification for its decision, and you as the counsel for the protester will get to review it. Maybe this will be, I'll talk about it a little bit more later, but I will bring up the fact that if you are the protester and there is protected information in the protest, it's worth noting here that you as the protester likely will not get to see the agency record because generally what happens is that the agency or the intervener or somebody will request a protective order, and only those people admitted to the protective order will be able to see the documentation. It requires whoever's handling the protest to be very delicate in conveying information to the client. So if you are the client, you just have to accept the fact that you're not going to get to dig through, likely not going to get to dig through the agency record, and you're going to have to take very high-level summary information from your counsel with respect to what the agency record provides. And in fact, they really can't even suggest anything, but they can give you some feedback based on the record as to which direction the protest should go. Like I said, we can talk about that a little bit more later, but the report is not going to be available to the protester generally, only to the counsel whoever's handling the protest. You can recover attorney's fees in certain situations if you're successful. That is an advantage. The cons, strict filing deadlines. If you do not file, and we're going to jump into that here next, but if you do not file within the required timeline, you are out of luck. There are very strict timelines, and you have to comply with them. That's probably my first and foremost tip that I'm going to leave you with for the day is that you have to comply with the filing deadlines at GAO, or you're out of luck for a protest. You see my second bullet there. We've already covered that, likely covered by a protective order, so I won't dive too deep into that again right now. Forum pros and cons for the Court of Federal Claims. When I say prompt, I mean prompt in that there's no automatic stay at the Court of Federal Claims, but what you can get is almost a very quick preliminary injunction, which essentially acts as a stay. So if you file at the Court of Federal Claims, you can immediately file for a preliminary injunction. Generally, you don't have to file for a temporary restraining order because it moves quickly, but you can file for a TRO and a preliminary injunction. And essentially what that does is it requires the agency, if you win it, it requires the agency to stay performance of the contract while the protest is being decided. There's no ability of an agency to override a TRO or a preliminary injunction, as there is at a GAO protest or agency protest. No strict timelines for filing and post-award protest. If you blow the timeline, if you blow the deadlines at a GAO protest, you can always go to the Court of Federal Claims, unless it will be inequitable. They basically apply, sort of a laches standard in filing at the Court of Federal Claims. As long as you don't just sit on it forever, and it would be inequitable to bring it later, you can still file at the Court of Federal Claims. Second bite at the apple, you can file your protest again at the Court of Federal Claims if you're denied at the GAO or you missed the protest deadline. It usually is not productive to file the exact same protest at the Court of Federal Claims if you lose at GAO. Court of Federal Claims almost always will follow the GAO's decision, not because it has to, but they're usually, the law is pretty well aligned. If you have new issues, however, new issues in your protest, then you might have some success at later bringing the same protest to the Court of Federal Claims with those new issues. Cons, most expensive. It is federal court litigation. Limited discovery, you don't get the full-blown federal court discovery that you see. And it's more of a home court advantage for the agency than at the GAO, most believe. That may be changing a little bit. It's really quite honestly subjective. No automatic stay of performance is a con. You have to go get that preliminary injunction that I discussed. Timing. Okay, let's cover this. This is the important topic. Pre-award protests of a solicitation, defects or issues that you have with the solicitation must be filed before a bid opening or before the due date for the receipt of proposals. This is critical. If you file after that date, it is untimely and your protest will get dismissed. So it's important to pay close attention to it if you see an issue in the terms of the solicitation. General rule for other cases. The general rule is that a protest, other than pre-award protest, must be filed no later than 10 days after the basis of the protest is known or should have been known. This applies to the GAO or agency protests only. As I said, Court of Federal Claims doesn't have this deadline. 10 days after basis of protest is known or should have known. Now, if your case involves a required debriefing, your deadline changes a little bit. If it requires a debriefing or post-award, it must be filed within 10 days after the offered debriefing. And then protests must be filed or that are filed before your debriefing, if there's a required debriefing, will be dismissed as premature. So this 10 days is an important deadline, but there's another important deadline. If there is a debriefing, you can get a stay, or even if there's not a debriefing, you can get a stay if you file within certain timelines. The timelines are if you file within 10 days of the award or within 5 days of your debriefing. So let's go through this. Pre-award protest. A contract may not be awarded until a protest is decided generally. There is a stay on the award of a contract if you file a pre-award protest. Now, an agency can override it if it can justify it. Post-award protests, the contracting officer must stay performance if an agency receives a protest within the later of 10 days of the award, which we just talked about, or 5 days of a required debriefing. A GAO, same. Contracting officer must stay performance if the agency receives notice from GAO within the later of 10 days of the award or 5 days of a required debriefing. Practical effect of this at GAO, if you want this contract stayed, get your protest filed at least 1 day before the deadline, so GAO has at least a day to give notice to the contracting officer and that stay is in place. As I mentioned, an agency can override a stay, but it has to provide written justification. It has to be urgent and compelling reasons. National security, or it's an urgent requirement. People will die if we don't buy this stuff now. Is an example. We don't need to dive too deep into that, but just know that just because you have a stay doesn't mean that you will always have the stay. There may be circumstances where the agency overrides it. All right, so let's talk about the tips. I know I'm running a little bit short on time. Next 5 minutes or so, 5-10 minutes, let's go over some of the tips. Procedure and jurisdiction. Timeliness at GAO is strictly enforced. The only real exception is if there's a significant issue exception. So get it filed within the 10-day deadline. If you want the automatic stay and there's a debriefing, get it filed within the 5 days. Significant issue exception to this is if the issue is not previously decided by GAO and there's a potential of widespread interest. If it is an important case, GAO might just take it up to resolve this important issue, even if it's not timely filed. I would not rely on that to miss a deadline. GAO generally does not review protests of the award of agreements other than procurements. Again, this goes back to if it's a grant or cooperative agreement, your venue forum is not GAO. It's Court of Federal Claims. This is an important one too. There's no jurisdiction at the GAO for a protest of task orders or delivery orders less than $10 million. Now there are a lot of nuances to this, rules that apply. How do you calculate the $10 million? But just be aware, if it's an actual task order or delivery order and it's less than $10 million, you may not be able to file that as a protest. Oh, I apologize. For pre-award protests, it is important, once you get that solicitation, if there is any question about it, you know, get a full legal review of the issue so you don't waive your ability to file a pre-award protest. It needs to be timely. It'll allow your, you know, whether you're on the business side or the legal side, it'll allow both sides to come together and discuss the issues so you're not blindsided later by getting a protest dismissed as untimely. If there are questions, ask the contracting officer. The Q&A sessions are a good opportunity to clarify. If they don't clarify it at the Q&A session, maybe you need to file a protest if the contracting officer refuses to clarify. The goal, obviously, is to get it fixed without having to file a protest. You need to let your in-house legal or outside legal or whoever's going to be handling the protest, let them know as soon as possible if you want to file a protest. It's not a wait till the next day type of thing because there are such tight deadlines. You need to get the ball rolling as soon as possible. Post-award protest tips. Again, notify whoever handles protests for you, notify them immediately if there's an adverse award decision and a possibility of protest. Quite honestly, if you have an adverse decision, you need to start talking immediately about whether or not a protest is possible, and generally that should include the person who handles your protest, whether it's in-house or outside counsel. Positive award decision, even if it's a positive award decision, the awardee can make an appearance as an intervener in a case to work with the agency to defend the decision to award to them. So often it helps if you get a notice of intervention, you certainly want to start discussing that, notify whoever's handling your protests. You need to immediately request a debrief if there's an adverse award decision. If you're interested in doing a debrief, if you have no interest of getting a debriefing and you're very confident that you don't need one, then I guess you don't have to. But I would advise if it's available and required, it never hurts to get it, and you should get it. You generally have to request it within 3 days of the award decision, so it has to happen quickly. So I would get that in ASAP. Remedies. All sorts of remedies are available in a protest. The contracting officer has very broad discretion in what would be appropriate as corrective action. See, voluntary corrective action, that happens a lot. Quite honestly, once you file a protest, if the agency starts digging into the record, their legal counsel looks at it, might hit them over the head for doing something stupid and tell them to go back and do it over. That happens. Again, they have broad discretion in determining how to fix that. And a directed award, if it goes to decision, GAO can say that, recommend that the award should be taken from one party and given to the protester. That is very rare. More often than not, there's a corrective action recommended. The they might terminate the solicitation, they might recompete it, resolicit it. There are lots of different avenues that may be taken, and you need to consider them carefully because, quite honestly, you may win your protest, but it may not get you anywhere. If the corrective action is maybe a resolicitation, quite honestly, you could end up losing the resolicitation on a fair basis. So It's something to discuss and consider before you file a protest. And of course, share all lessons learned with the business development team. It's important to communicate this internally so they know how to approach things. Try to eliminate emotion from decision. This is one of the most difficult things to do for a lot of people, and quite honestly, I've had clients who said, file a protest. I know that we might lose, but I'm pissed off about it. And you know, if you want to do that, that's great, but you need to you understand that emotion might cloud your decision. The sustain rate generally is lower than 20%, and it's been in a decline since 2012. Sustain rate means those cases that go to decision at GAO. It's been very low. For 2015, it was 12%. But an overall increase in effectiveness, if you combine decisions, sustains, and corrective action, it's 45%. So almost half of the time, the agency does something different or is told to do something different through a decision. The most commonly sustained grounds in 2015 were unreasonable cost or price evaluation, unreasonable past performance evaluation, failure to follow evaluation criteria, inadequate documentation of the record, and unreasonable technical evaluation. So you can sort of see a trend there, right? It's a lot of unreasonable evaluations, but also failure to follow their own criteria. Look at the agency record objectively, and this is more towards, obviously because of the protective order, this is geared more towards counsel or in-house counsel that's handling it. They need to look at the record objectively. I have had protests where once we received the record, my advice to the client was to just drop it because what they thought had happened didn't happen. You need to use it as a reality check. Although protests are fairly common, you also have to evaluate the impact on relationships. Most agencies understand that protests are part of the game and they're not going to hold it against you. But just keep in mind how you go about it. Costs are not always available, especially if it's a corrective action taken by an agency. It has to be, if the agency, if it was a clearly meritorious protest and the agency sat on its corrective action for a long time, maybe you can get protests or costs from GAO. And it's important that this sort of ties a lot of this together. You actually have to show actual prejudice. This goes back to the interested party. This goes back to taking emotion out of it. You have to be able to state and show in your protest that you were actually prejudiced by the agency's actions. All right. So if I haven't put everybody to sleep, it looks like we still have a few minutes for questions. More than happy to field any questions you have, and don't be shy. If I don't know the answer, I can get it for you later, and I'm happy to kick things around.
Thank you, Paul. Great information. As a reminder to all our attendees, if you do have a question, please type that question in the webinar dashboard on the right-hand side of your screen under the question tab. Paul, we do have a couple questions here. First one, why wouldn't a contractor always file at the Government Accountability Office if it gives them a second chance at the Court of Federal Claims?
Right, and that's a good question. That's usually the case. I mean, people will generally file, as I said, at GAO because it's a less expensive forum, and the opportunity to, as I had mentioned, the opportunity to file at the Court of Federal Claims later it's a good opportunity, a good second bite at the apple. Unless you have new issues, though, you're unlikely to get a different result at the Court of Federal Claims. So it's important to pick your forum very carefully at the outset. Yes, you do have a second bite at the apple. Now, with respect to why would somebody just wouldn't go straight to Court of Federal Claims in certain situations? Really, I mean, it's a matter of cost. If you can get the same or similar decision at GAO rather than going to the Court of Federal Claims, unless you've blown your deadline for filing, it usually makes sense to go to GAO and Court of Federal Claims. There are some there are some instances, I suppose, and you should look at it closely, where the law might be slightly different as applied in at GAO and the Court of Federal Claims, and you can look at that to determine which is the better forum. Maybe the law is more favorable at the Court of Federal Claims on a certain issue that's relevant to your protest. In that case, you might save time and money by just going straight to the Court of Federal Claims instead of going to GAO and fighting the battle there. So hopefully that answers the question fully.
Great, thank you. Another question here. How does one know if the government has performed a price-cost analysis?
Well, one of the ways that you'll know is you're going to get a notice. If you're an unsuccessful, you're going to get a notice regarding who's the successful offeror, and if for some reason the winning offer comes from somebody that you know has underbid it intentionally or unintentionally, maybe they just don't understand it. That's one way to know for sure. That's one way to know that had they looked at this, had they performed a real price or cost realism analysis, they would have discovered that there was no way that they could have performed the scope of work set forth in the solicitation for the amount of money that they proposed and for which the contract was awarded.
Great, thank you. We do have a few more questions here. What is the typical legal cost for protest to the GAO?
That's a good question, and obviously one that I get a lot when I start talking to people. It really depends. It really depends, obviously, on how quickly GAO or the agency takes corrective action, or if it goes to final decision. Are there supplemental protests? Are there procedural issues that need to be resolved? Is there going to be a hearing? So there are a lot of factors that go into it. I would say getting a simple protest, a very, very simple protest on file, you can't rack up a lot of costs because it has to happen quickly. So you can get a protest on file for a reasonable amount of money. I would say that you can certainly expect that it's going to be in most cases over $20,000. It just really depends on the issues and how many issues there are. Now, once you get into, if you get the agency report, that's when the real work starts, quite honestly, if there are no procedural issues. You have to review the report, and depending on the complexity of the protest, it could be incredibly thick. I've had to go on site before and take people with me just to get through an agency report in a timely fashion. It requires research. It requires a lot of time and effort. If you get through the agency report, file your comments, and file a supplemental protest, it quickly gets over 6 figures. So it's difficult to pinpoint it, but that's I can tell you that it will exceed 6 figures if you get into a full-blown protest.
Great, thank you. Another question here. Could a large business be considered a legitimate interested party if they make a pre-award protest regarding a solicitation designed for a small business only?
It would have to, well, you would have to show that it was improperly set aside. If that's what you're talking about, if it was improperly set aside as a small business solicitation, then possibly. But if it was properly set aside as a small business set aside solicitation, a large business is not an interested party. And if you have one thing, that's a good question, because the one thing that I didn't cover, and it's a whole nother issue, but one thing to keep in mind, if you are a large business and you don't think that there are enough small businesses out there to provide the product, and you think that somebody is lying about their small business status, that's a small business protest that does not go to GAO. It actually, you file that with the contracting officer, and then that gets forwarded on to the SBA for a determination. So that's an important distinction. If you think that you need to protest somebody's size status in connection with the procurement, that'll end up at the SBA. Hopefully I answered the question, if I understood it correctly.
Great. Thank you so much, Paul. Really appreciate you lending your considerable expertise to this program. I know everybody on the line really appreciated all the information. It does look like that is all the time we have for today. Thank you, everyone, for joining us on the line. Do make sure to mark your calendar for upcoming PNDC events, all available at pndc.us. We will have a GSA Proposal Development webinar January 7th, a War on Talent webinar regarding recruiting and retaining employees January 15th, and our Government Contracting Conference will be in Oregon on April 28th in Clackamas, right outside of Portland. Paul, thank you again for lending your considerable expertise to the program.
Thank you.
And, great. The webinar has now ended. Thank you, everyone, for joining us.